And I'm going to, before we start the meeting, I'm just going to explain, almost every single thing on this agenda is going to get passed unless a board member says not to. Mr. Stone, John Stone, who's our board member from Fairfield, he hurt his hand and he had to go up today for a follow-up with his doctor and it was a meeting he couldn't put off, but because of one of the matters on the agenda has to be held within 30 days, we had to have this meeting today, but it is unlikely that we're going to make any decisions on anything. This board, we can meet with a quorum of 4, but we don't. In the past, we have never made any major decisions without a full board. So I'm just kind of explaining why this agenda looks very full and it's not going to be really.
How's the temperature?
They're good.
You and I.
It's hot.
See, I'm sweating. That's why I'm asking somebody vote with me to turn it down.
Turn it down, go for it, girls.
Close to it. Enough to it.
The girls get to decide. Guys don't get to make the decision on the temperature control.
This is Larry Hamilton's office. He's not there.
Open it up.
So, yes, that's what I'm going to do.
Airflow.
And he knows there's this meeting and he doesn't plan to be here.
That's
so
fine.
If we need to, we can open the mayor's door, but.
We're all good. Yeah. People can always put more clothes on, but you know,
Yeah.
so much
Yes.
off.
Nobody wants me to take my blazer off, trust me.
Okay, is everybody ready? Wait till we get this in. Okay, is everybody ready? Okay. This is calling to order the meeting for the Joint Board of Ethics for March 27, 2018. We do not have a full board present today. John Stone is absent due to unforeseen circumstances that could not be changed. So most of the items on this agenda will be passed to the next meeting. Unless a board member tells me otherwise, that they want to do otherwise. The first matter on the agenda is the election of the chair and the vice chair position. There is no requirement that we handle this matter today, so I am suggesting that we table this and handle this at the next meeting. Do any of the board members disagree or agree or have any thoughts on this matter? Brad? Are you okay with passing it to the next meeting?
It's fine.
Austin? Are you okay too?
I'm fine.
Okay,
Yes.
well, let's pass that because that is an important decision and it would be great to have a full board with John here for that. He told me he was okay if we did that without him, but there's really no requirement that we do so we'll just pass that. The next is the approval of the minutes. Have you passed those out?
They're in each of the board members' packets.
Okay. John has asked that we, again, there's no requirement we approve these minutes at this meeting. He has asked that he be able to review these minutes before we approve them. So if nobody has a problem with it, I would like to table this matter to the next meeting. What do you think, Jim? Are you okay with that?
Yes, I'm fine.
Austin?
Okay.
Brad? You're okay with that? Okay. So we'll mail those minutes out to John and just address that at the next meeting. The next matter on the agenda is our expenses and income for 2017. We went ahead and passed those out for the board to look at. Of course, under section 21A of the ordinance, those expenses, we didn't have any income come in, it's just pure expenses, and they're fairly nominal actually for this 2017. But of course, a percentage of these expenses have to be billed to the city of Fairfield, and since John Stone is our only Fairfield representative, he has asked that we please, and even though it is a nominal amount that would be required, he has asked me if we could please table this matter and have it heard at the next meeting, which I agree with. Does anyone have a problem with that? Brad doesn't. Jim, do you care?
I'm fine.
No.
Austin? Okay,
No.
so we will table that as well. The next matter on the agenda are the 2017 filing statements of financial interest. As usual, we have had some people who have failed by just inadvertence for the most part. And some, we have some people every year who think that since they didn't serve the entire year, they don't have to file this. And so they don't. We've had most of the people who have did not file timely by the end of business December 31st, 2017 have filed at this time and have filed a request for an extension. We still have 3 people that have not responded. They have also not received the actual notice, and they have their 60 days from of their notice has not expired yet, and that won't happen until next week. So I would request and suggest that we pass on this matter as well, so that we give these people the time they deserve to comply. And so my recommendation is that we also table this motion until the next meeting. Brad, you're okay with that? Are you okay, Jim, with that?
Yes.
Austin, are you okay with tabling this? Okay.
Can I make a suggestion?
Yeah, I guess.
Well, on these, working with Mary, because Mary and I work really well together, but if you'll notify the agencies that we can help
Okay.
herd those cats.
Okay.
So
Yeah, we do that, and I appreciate that.
Yeah, I mean, because if you're sending them out, let us know that you need it, and we sure can help remind.
Okay.
Because we've got all the emails, and we can send it out, but you might want to do that with other agencies too, so we can help do that legwork.
Okay, thank you so much. Thank you. Yeah, we try to do that.
Mary's good at it.
Mary's good at everything.
But I mean, we've got like almost 40, so I mean, we can help.
Okay.
Yeah, we can help
I
call them
appreciate
and let them know.
Thank you so much. I appreciate that. Okay, so we will pass on formally doing anything with the statements of financial interest for 2017, which brings us to the matter that cannot be put off, which is the preliminary inquiry regarding complaint number 2018-01. Under section 24 of the ordinance, B, within 30 days of filing the receipt of a proper complaint, which this complaint was proper insofar as it met the requirements to be considered a complaint. The Board of Ethics shall conduct a preliminary inquiry concerning the allegations contained in the complaint. That is what is happening today. We are just simply having a preliminary inquiry. At this meeting, the person who has had the complaint filed against them has the opportunity to respond to the allegations in the complaint. This person also has the right to be represented by counsel, but that is definitely not a requirement. This person has the right to appear and to be heard under oath. That is not a requirement to be put under oath for this meeting, for this inquiry, and has an opportunity to offer any evidence in response to the allegations contained in the complaint. Now, since this is not a hearing, there's no hearing officer here, there is no necessity to be put under oath, and the board is not to ask substantive questions, only questions of clarification. If the matter were to go to a hearing, then the board at that time would have the ability and opportunity to ask substantive questions. But at this point, this is simply an opportunity for the person who had the complaint filed against them to respond and offer any verbal evidence, any physical evidence that they want to, as far as responding to the complaint. After the preliminary inquiry, now the board is not required to make a decision within 30 days of the complaint being filed. We're only required to have the preliminary inquiry within 30 days, which is why we could not put this meeting off. Even though we don't have a full board, legally we had to have the preliminary inquiry. But after the inquiry, the board shall make a determination based on the inquiry whether, number one, the complaint filed is within its jurisdiction, and if so, number two, whether the complaint alleges a minimal factual basis to constitute a violation of the ordinance. If the board concludes that the complaint is outside of its jurisdiction, frivolous, or without factual basis, the board shall terminate the inquiry, reduce the conclusion to writing, and transmit a copy of the decision to the involved parties. So, at this time, we are here to conduct a preliminary inquiry and permit Mr. Mathis to respond to the complaint and offer any verbal statement or any other evidence, written, video, whatever you would like to do. I need to ask, do you want to appear under oath?
Not under oath, not represented by counsel.
Right.
Really no witnesses.
Well, and if we went to a hearing, you could do that at that time. This is just an inquiry
Just
right
a-
now. This is just to see whether we get to it.
But I expect to give you all one document,
Okay,
so it'll be one exhibit.
okay. Do the board members all have a copy of the complaint in front of them? And again, the only questions that can be asked are from the board. It's,
I need one. I've got one, but I didn't know.
okay. The only questions that can be asked are questions by the board members and not substantive questions, but maybe if Mr. Mathis says something and you don't understand the answer, say, I don't understand what you're saying. You know, can you please clarify? Or when you say that date, can you clarify what date you mean? So we're not asking substantive questions of why did you do this,
Sorry,
or
that
why
can
did you
blur
not do
out.
that, or share that. It's just to make sure we understand the statement. And if we were to go to a full hearing, that would be different. We would be able to ask substantive questions at that time and cross-examine, but we can't do that at this point. Okay. All right. Ready when you are.
I really didn't know how you were going to proceed today. I thought you'd be asking me questions, so I have read Mr. Kurzov's complaint. Honestly, I had a hard time following some of it, but when I look in the back in his conclusion, he states that the violations that he alleges that I had resulted in an improper planning and zoning vote and resulted in the Nelson Fiscal Court making a subsequent vote to endorse the planning and zoning vote. So, starting with that, I understand why he has said the things he does. He's trying to get my vote disqualified because I participated in the public hearing, I participated in our planning and zoning meeting, and voted one of the affirmative votes that to recommend amending the PUD permit for the Woodlawn Springs development. So,
What is it, PUD?
planned unit development,
Okay.
just a PUD. So,
Thank you.
permit. So, I'm gonna, again, if you all want to ask questions, it'd be a whole lot easier than trying to go through this. So, I tried to identify the conflicts and the violations that he alleges. And I guess starting in the beginning, he says that I had a conflict because of the applicants. The applicant was Woodlawn Springs Golf Course. Its owners were Chris Osborne, Allison Osborne, Chris Osborne's dad, and Allison Osborne's mother. How detailed do you want it?
It's your decision. This is your,
Okay.
this is your opportunity to respond to what's in the complaint. You're
Yeah.
not required to respond to things that are not in the complaint. And you don't
okay.
have to respond at all. It's just whatever evidence or what you want to
Okay.
tell us. And you can
Again,
confirm.
it's hard to take it in order, but He cites Jody Hayden in here. And he says that as my role as secretary, that I argued openly for the acceptance of these changes proposed in the application. Well, at the public hearing, as is customary on every one we do, the commissioner will start on one end, and, you know, what Commissioner so-and-so, what do you think? What do you think? What do you think? What do you think? And he goes down the road. So I stated my opinion. I don't know that I was arguing openly for acceptance. As it was, it was tabled, and then the meeting was held later. I did vote for the proposed change. And he says that my vote was a conflict of interest for multiple reasons. And he cites my business interest as being a conflict, and then cites a section 5 of the Ethics Code. He says that I own multiple businesses in Nelson County, such as Bardstown Asphalt Company and Eagle Construction, and I'm on the board of Wilsonville Bank. I don't know what being on the board of Wilsonville Bank has to do with this. He says that these are two paving companies. They're not. It's one paving company. Bardstown Asphalt Company has no paving equipment. It has trucks. It's a trucking company. He said by virtue of my financial disclosure that I failed to disclose TAPCO Incorporated. TAPCO is another trucking company. And he's gone through the Secretary of State's website, which does not reflect ownership. It does reflect directors and officers of a business. The Ethics Code requires disclosure of over 5% interest in a company. So, again, why he put Wilsonville Bank, I have no idea. He says I did not disclose TAPCO. I had on prior occasions. That may have been a mistake. Again, I'm trying to dot I's across T's when I do these financial disclosures. I personally don't own TAPCO, the stock in TAPCO. I do own Bardstown Asphalt Company. Bardstown Asphalt Company owns the stock of TAPCO. It's a wholly owned subsidiary. So it's redundant to have both. That's why I left it off last time. Again, trying to dot I's across T's.
Can I ask you a question?
Yeah.
Would it be fair to state that TAPCO and Bardstown Asphalt are DBAs of, they're underneath, or are you saying they're wholly owned subsidiaries of Mago?
Mago's separate. I own 18% of Mago.
Okay.
That's all. I do own 100% of Bardstown Asphalt Company. Separate company, totally separate. Bardstown Asphalt Company owns TAPCO.
Which is your trucking operation?
Yes, yeah. It's a wholly owned subsidiary.
Okay.
Okay. And Mago and Bardstown Asphalt are not totally, they're just totally separate. So that's the reason that was not on the last filing.
You're talking about 2017 filing?
Yes, ma'am.
Yeah.
2017. And, okay. Again, the ethics ordinance requires disclosure of 5% or more, of over 5% ownership, not dealings. So it's not dealings, and the fact that he said I was president, that doesn't, again, I just have a hard time in finding, understanding his reasoning in trying to connect that. He says that the very nature of the business, the fact that it does construction for Nesson Fiscal Court, would reach a substantial conflict of interest in many areas of construction. The ethics ordinance, I think, states that anything competitively let is excluded, and everything that MAGO does with the fiscal court, city of Archtown, whatever, is competitively let. And that has nothing to do with this application, the application that was voted on anyway. I believe he said that, he says there appears to be no recusal by Mathis at any time on such votes and issues. I recuse at the appropriate time. And I'll give you an example. If MAGO has a contract to do paving, and that contract is on property that's subject to a zoning vote, I recuse. And prior to every meeting, I'll check with our estimating department, our engineers, and just see, if we got anything going on. Because we get our packets ahead of time from the planning and zoning staff. And if I have a conflict, because MAGO has a contract to do paving, I will recuse. If we are estimating paving on something that comes up, even though there's no contract, I recuse. If we have no contact whatsoever with an application, I have no conflict, and I will vote. I'll give a recent example. When we ended up not having a quorum was the Bischoff request. We didn't have a quorum because so many of us recused, and I was one who recused. We did not have a contract with Bischoff for that particular lot, but we did have a contract with them to do paving at another location. That was too close for me, I recused. In this particular case, I was asked if I had a conflict. Again, at the time, I had no idea who the owners of Woodlawn Springs, who the members were of that development company. And I disclosed to our commission attorney, Mike Cohen, what my relationship with Jody Hayden was. Jody Hayden is not a member of the applicant, but his wife is, his son-in-law, and his daughter, and then his son-in-law's father, whom I've never met. And let me say this, I have seen Jody, I think, twice in the last year and a half. One was coming out of a funeral home, and one was at a groundbreaking for the Kentucky Owl. I have no business dealings with him, but again, to avoid the, just to make sure that I was free to vote on this, I had a conversation with Mr. Cohen. He confirmed by email to our director, James Johnston, that I, in fact, had no conflict on this application, and I was free to vote on it and participate at the public hearing and our meeting. So I think everybody's...
Can I ask you a clarification question, please? You said you were asked if you had a conflict, but you didn't say who asked you. Are you talking about Mark?
Mike and
Mike and me
I
asked
talked
you.
about it.
Okay, because you just said you were asked if you had a conflict, and you didn't say who did the asking, but you were referring.
I think Jan
Oh, okay.
asked me.
That's fine. I just
And-
want to clarify
Yeah,
if someone else had
from
asked you.
the
to-
planning and zoning
Okay.
staff.
All right, thank you.
And Mike's the commission attorney, right?
Yes, sir.
If you could give us just a minute to read this.
Sure.
That would be great. Thank you. Did I say so? Thank you. Okay, I think we've all finished reading this, if you would like to continue.
Okay. So after discussing Mike's letter, I told Jan, I would be able to participate. And I did. Let's see. Oh, another thing that Mr. Turzop says is that he went to the not Secretary of State, the election registry, and he printed out all my political contributions for the last 10 years. And in 1998, I donated $100 to Jody Hayden's campaign 20 years ago. And I made another donation to his campaign for state senator in 2009. And so you can, I don't think that's covered in the ethics code any place, but so anyway, I don't know why he printed it. Well, Mr. Turzop calls it a conflict of interest. I don't think that's a conflict of interest. I think that addresses everything that he's alleged, and I guess I'd be glad to answer any questions.
Unfortunately, because this is just at the preliminary inquiry stage, we're not permitted to ask substantive questions because the other party's not here.
Understand.
They're not here to be able to listen to it or to asked the
Okay.
wrong question, so we don't have that right.
Okay, I'll just make an observation. I'll say this. I have been on the planning, I think Gus Wilson appointed me, but I started serving in 1990. And I have never had anyone say that I have violated our local ethics ordinance. Now, it's very convenient for Mr. Terzop to, because he does live in that neighborhood, it's very convenient for him to make these allegations to try to get my vote out, as kicked out, as he concludes in his complaint. But
May I ask you a question?
Yes, sir.
You said Mr. Terzop lives in the
Woodlawn
property
Springs.
under question? Okay.
Mhm. Yeah. So I understand his motivation, and I know hasn't been in the community long, and he doesn't know me, and I don't know him. I've never spoken with him, or Mr. Thrasher, who delivered the complaint for him. And, but, you know, again, trying to boil down his complaint and try to separate out the particular conflicts that he alleges, you know, I don't have any connection with the applicant. I did donate to Jody Hayden's campaign 20 years ago and 9 years ago. He is not the applicant. A letter from Planning and Zoning's attorney cleared me to vote on this. I did not report TAPCO on my financial disclosure because I don't own TAPCO. Again, following the financial disclosure appropriately. And furthermore, since 1990, when I was appointed, I have always recused myself from participation in any vote when it was appropriate, and I explained those circumstances. So,
I do have one clarification question. When you were talking about the vote that you did, that we're talking about, this is about apparently the planning and zoning vote, and you said you did vote on that matter. Can you tell me what the final vote was?
it was 4-2. 4-2.
And you
Yeah.
voted in, you were in the 4?
I was one of the 4. Okay, now,
Okay, go ahead.
Chrissy, let me, that would have made the vote 3-2, you think? But actually, we would not have had a quorum,
Okay,
so there would not have been a vote.
okay, gonna be my
And it would have
clarification
gone-
question.
It would have gone to fiscal court at that point without a recommendation from the planning.
Okay, I gotcha.
May I ask another question
Yeah.
related to that? You say you wouldn't have had a quorum. You being present for the meeting would have established a quorum for the meeting, but abstaining from the vote necessarily, is there a minimum required number of votes? Or is it a quorum that you're,
You can answer him, you can't answer us, which.
We have to have a simple majority of those present to vote on any zone change.
so there's no presumptive number of votes to
There,
move forward a zoning application?
there's 11, so we have to have a majority of the total membership there to do business, so that would be 6.
6.
And then we have, for a vote to go forward to fiscal court, we have to have a simple majority of those 6. So we would have had to have 4 to move something forward.
So it would have, okay.
So the
If it
reason
was
I'm
3-2,
asking
it
that
would-
question
Yes.
is
So 3-2 would have failed?
Correct.
Oh, okay.
3-2.
You wouldn't have been enough people.
Wouldn't,
That's what I just wanted a clarification on, I don't need to know who voted.
Well, that's
Other
not
than what
either, I'm
you
just saying,
did, but
I'm
I'm just
more
trying to-
looking, I'm trying to drive down into whether or not that him not voting would have changed the outcome of the vote.
And we, yeah, yeah.
There are instances when people abstaining that their presence
Would be in
goes with the majority
But
of the
not,
votes, but not in
not
this instance.
for how Mark is explaining it.
Right.
Okay, that's all. I don't want to, we
Yeah.
can't get it substantively too into that. I just needed a clarification because when you talk about the vote, I wasn't understanding exactly what you meant.
And also, when I recuse, or when any of us on the commission recuse ourselves, we leave the room. We're not even in the room.
I don't have any other clarification questions. Do you have any?
I do not.
Jim? Austin, do you have any? Okay. I can't, at this time, I'm gonna make a motion to go into closed session, but before I do, I wanna clarify procedurally something. Okay, under the ordinance, we have to have this preliminary inquiry today. We have to at least start it today, because of the timely manner required by the ordinance. We are not going to be doing a final vote on this, and making any formal decision. And of course, in closed session, we can't do that anyway. We can't make any decisions in closed session. We can only discuss matters that are appropriate. You are welcome to stay, and there is always a chance that we might have another clarification question we need to ask you. But we won't know that till we go into closed session. But we can't ask you anything substantively, so I personally don't see us needing another clarification, but I don't want to,
I'd be glad to
it's up to you.
be here. I mean, I know you've got this 30-day limit.
Well, no, we just have the 30-day limit on having to have this, where you have a chance to respond. We don't have a choice on that. We had to have that with today, by within the next day or two. I mean, we were running out of time. We're at the end of the 30 days. But we won't be doing a vote or making a final decision on how to respond to the inquiry without a full board. And I don't know, there is a chance John Stone may show up, because his appointment was this morning. And I told him if he felt up to it and he wanted to, if we were still here in the meeting, formally our meeting's still going on, he could, join the proceedings at that point. I don't see that happening. I don't see him showing up. So what we will do is we'll just send out a notice for when we set up our next meeting. And, typically what we don't, even in these circumstances, even if we had a full board, we typically don't announce at the meeting what our decision is. We conform to the ordinance, and we reduce it to writing, and then we send it. If you're here, we can hand deliver it to you, but we don't announce any kind of decisions at meetings anyway. So even if you came to the next meeting, we may end up having a meeting and just deciding this matter and putting it in writing and sending it out in the mail. So, like I said, this is the first time this has ever happened where we haven't had a full board at an inquiry. So I unfortunately can't tell you exactly what's going to happen. But
Anything else I need to add?
okay, all right.
Chris, I'd be glad to hang around.
It's up to you. I mean, I can't predict what we're going to do and discuss in closed session.
You go in closed session, I'll be out there. If you need something, just
Okay. If we did, it would just be again, we wouldn't be anything substantive really, other than just, can you clarify this date, or can you clarify what you said when you meant this? We
Sure.
can't question you about it, because that would be inappropriate. It wouldn't be due process for Mr. Terzak.
I'm sure.
Because he's not here. And I do want to make a note for the record. I spoke with Mr. Terzak last week. He asked me what was going to happen at this preliminary inquiry. I briefly discussed the procedure. He said he did not plan to be here. He did not want to be here, and he understood and was glad you were having an opportunity to present what you wanted to present. So he did know about this meeting. He just chose not to be here today. So anyway.
Okay.
All right, at this time, I'd like to make a motion, we go into closed session under, under KRS 61.8101 sub F, discussion or hearing that might lead to the discipline of an individual employee, general nature of the business to be discussed, potential ethics violation of standards of conduct clause regarding complaint number 2018-01. Do I have a second? Okay. Any discussion? All in favor? All right, we now go into closed session.
Let me turn this off, please.
I wouldn't, it's up to you, but
You don't anticipate any action coming out of this?
I know it won't happen. We won't.